Hi, we'll start talking now about negligence. There are two important non-intentional torts, negligence and a category called strict liability, otherwise referred to as liability without fault. Of the torts that fall within strict liability, we'll be studying one, which is products liability, and we'll do that in a separate um, podcast. But for now, we're going to start with negligence. Negligence is by far the most commonly sued upon tort. It is a non intentional tort. It has four elements, and there, you can see them listed here. If any of these four elements is missing, then the tort has not occurred. So this is an essential list to understand. We're going to break this list apart into separate podcasts along with the important defenses to negligence. In this podcast, we'll start with an overview along with discussing duty and a breach of that duty, sometimes called a failure to exercise reasonable care. Now, negligence, again, refers to non-intentional harm. One more time now, torts are rules imposed upon us by society. They have nothing to do with our agreement to abide by them or not. Instead, they reflect a societal viewpoint on what behavior we should expect from others. Importantly, you must show that your harm occurred in the way required by the tort. It's not enough that someone behaved irresponsibly. You have to show that it caused a particular financial harm to you. Okay, so let's get started first off by looking at the elements. First, you have to show that the defendant owed the plaintiff a duty, and that duty is to exercise reasonable care. The second of the four elements is a breach of that duty, sometimes called a failure to exercise reasonable care. The third element of negligence is causation, and there's two parts to causation. Again, you must prove both. The first part of causation is actual cause, sometimes called the but-for rule. If it hadn't been for but for the defendant's conduct, would that injury or loss have occurred to the plaintiff? And secondly, proximate cause. Was it reasonably foreseeable? Should the defendant have anticipated that the plaintiff could be injured in the way that he was? And finally, damages. In this podcast, we'll talk about duty and breach of duty. What's the test for duty? Well, we're going to take a simplistic approach, and that is, should the defendant have anticipated that the plaintiff was relying on her for his safety? Distinguish between moral duties and legal duties. They overlap, they're not identical. So, in our hypothetical, suppose that Armin, who's a great swimmer, is walking on the beach and hears Yolanda screaming for help in the water. Does Armin owe a duty to help Yolanda? Well, morally, does he owe a duty? I'd say yes. If you can help someone else without undue risk to yourself, absolutely. But that's not the test. The test is whether a legal duty is owed. And that test is, should the defendant, Armin, have anticipated that the plaintiff, in this case Yolanda, was relying on him for her safety? Was Yolanda relying on Armin? Well, if there's no relationship between the two of them, then the answer is no. Yolanda didn't go swimming because Armin, a stranger, is walking down the beach. Can you change the facts so that there would be a duty owed? Sure. What if Armin was the lifeguard on duty at the time that Yolanda is struggling in the water? Should Armin have anticipated that Yolanda was relying on him for her safety? Of course. She may not have gone swimming otherwise. How about if Armin and Yolanda are friends and Yolanda was reluctant to go swimming until Armin said, "No, go ahead, don't be scared, I'm here." Should he anticipate that Yolanda is relying on him now? Yes. The circumstances then require that you use this rule. Should a reasonable defendant have anticipated that the plaintiff was relying on him for her safety? That's the test. The test is not, is there anything the defendant could have done that would have prevented this accident? That's not the test, and that's going to be your impulse sometimes to go to. So fight that impulse, make sure you understand the rule. Years ago, in the olden days when there were payphones all over the place, there was a payphone in downtown Los Angeles, and it was apparently well known as being a place where people dealing drugs and engaged in other illegal activity would go because it was, it was safe. Unlike a mobile phone, it doesn't do law enforcement officers any good to try to trace it when the phone call when it simply goes to a payphone. A passerby was near that payphone and was attacked by a criminal and injured. And the passerby sued the phone company saying, your having your phone in this location attracted criminals to the area, and I was attacked, and therefore, phone company, you were negligent in failing to monitor access to this payphone. Well, problem number one for that plaintiff was, did the phone company have a duty to that passerby? Would a passerby have been relying on the phone company to monitor the safety of the area around a public payphone? And this proved to be an insurmountable barrier for this plaintiff. A Los Angeles court, and then on appeal it was affirmed, ruled that the phone company should not anticipate that people in the vicinity of its payphones was relying on the phone company to manage the physical safety of people in those areas. There was no duty owed, and therefore there was no breach of duty, and therefore the phone company was not liable for that person's injuries. Therefore, be careful. Simply because someone could have helped does not by itself create a legal duty. The second requirement of duty is that the duty was breached, and that means broken. If the duty is an obligation to act with reasonable care, another way to say this is a failure to exercise reasonable care is what constitutes negligence. One thing to be careful of is the level of duty one expects depends on that defendant's skills and their knowledge and their abilities. What you're looking for is reasonable in light of that particular defendant. Did that defendant behave like a reasonable person? So let's go back to our hypothetical with Armin and Yolanda at the beach. What level of care would you expect from a lifeguard on duty who has stepped in to help Yolanda? A high level of care or a low level of care? Well, if it's a swimmer who's choking, I would reasonably assume that the lifeguard has some training in how to help people who are suffering from the effects of swimming. I would assume the lifeguards had some sort of CPR training. Therefore, if the lifeguard failed to administer CPR correctly, I would say most courts would view this as a breach of duty of care. How about if it's simply a fellow beachgoer who stepped in to help? Now, again, reviewing what we talked about before, did the beachgoer who assumed they have no relationship with Yolanda, they're not working as a lifeguard, they're simply a random person walking down the beach, did they have a duty to help? No. But let's say that they assumed a duty to help. In other words, they're a good Samaritan and they've stepped in and they're trying to help. What level of care would you expect? In other words, if that passerby did not know or administer CPR, would you say that they were negligent? Would you assume that a reasonable person walking down the beach has been trained in CPR? No, not necessarily. It's nice if they have, but you wouldn't expect that to be true. And therefore, you would expect a lower standard of care from a passerby on the beach than you would from a lifeguard. Finally, how about a 4-year-old? Suppose a 4-year-old's trying to help. How high a level of care would you expect from a 4-year-old? Well, not much. So put yourself not in your position, but in the position of that particular defendant and ask yourself, Did that person, given their age, their life experience, their training, their position, did they act like a reasonable person under those circumstances? And again, as a caution, remember that we're not expecting perfection. Negligence has to do with what a reasonable person would have done, not what a perfect person would have done. So, one more time, negligence is a non-intentional tort. It has 4 elements. The first 2 elements are the existence of a duty and a breach of that duty. Okay, now in a separate podcast, we will talk about the remaining elements.